Now, sometimes we're wrong. I mean, that happens occasionally. But usually the mediator is echoing the 2 or 3 big points that either we need to hear or the other side needs to hear. And sometimes it moves the needle and it's confidential. So that's one of the really big benefits is everybody can be open and candid during that time.
Right. There's no fear. Anything you discuss in a mediation, as Brian said, is strictly confidential. And there's actually 2 types of confidentiality within the mediation process. So typically, you'll start out in a room with a mediator. The lawyer representing the claimant will give an overview of their case, of what they think is important, speaking directly to the defendant and a representative of the defendant's insurance company if there's insurance involved. Then the defense lawyer will have an opportunity to tell the plaintiff what they're seeing, how they see the case. And really what each side is doing at that point is they're pointing out the major points, what they think is going to provide the biggest risk to the other side. The mediator listens, and then everything that is said kind of in that open session is completely confidential. So what that means is if you have a case and you're worried about, well, I don't want to tell this other side this because they may use it against me at trial, the rules specifically prohibit somebody from saying, but in mediation, you said you would take this much money, or you said you were going to do this. Everything that is said in mediation is confidential. Once the beginning session is done, then the parties will separate and the mediator will go back and forth to each room. And when he comes into the plaintiff's room, he's telling the plaintiff about their risks. When he goes into the defense room, he's telling the defense about their risks. The things that you tell the mediator are also confidential. So you have much more control, I think is one of the big things I've seen in mediation, is the control and really self-determination.
No, and again, I think that's one of the things, I forget which mediator says it, but in mediation, you are a decision maker. At trial, you are a risk taker, you are a gambler. Now, Bay County juries so far have been good to us in the cases that we've tried. I think we've had maybe one bad result, I think one in Jackson County. I'll disagree with, but besides that, you got 6 strangers who are hearing evidence one time, and then they have to make a decision about, what was it worth, everything that you've went through and everything you'll have to go through. Same thing if you lose a family member, what is that worth? And that is a very difficult thing for juries to decide. And there is a lot of risk on the insurance company side, but there is also a lot of risk on the plaintiff side, who we represent, where you just don't know what a jury might do. Some people might think, if you lose your spouse, $1 million is fair. Some people might think $25 million is fair. So again, I think that loss is priceless, but our civil jury system is how we, recover losses in those situations. And so there's just a lot of risk in those types of cases, and you just never know what a jury might do.
Right. Again, we're taking your calls live, 850-392-1544. If you've got a question about an insurance claim, give us a call, and we'll answer those questions here on the air. Brian, one other thing you mentioned, and I know we kind of got off onto a tangent with mediation, which is a part of the trial, the lawsuit that involves insurance. But, one of the things I always hear also from people is, how long is this going to take? What's the process? How long is this going to take? When somebody comes in and asks you that question, let's say somebody was rear-ended in an automobile accident, clear liability, there's no dispute as to who caused the wreck. The only issue becomes the damages, the extent at which the person was injured, whatever their future medical care might be, what their past medical care was it reasonable, what their injuries are, how it's going to affect their life. Somebody comes into your office and says, I've got this case, how long is it going to take for us to have a resolution? What do you typically tell them?
So, assuming they are coming in, shortly after an injury occurs, I tell every single client the same thing. It really depends on your medical treatment. For me, most of the time, but there are exceptions, it will depend on your medical treatment, because I want to negotiate a claim after a client is done receiving all the medical treatment they have, or they plateau or reach what's called maximum medical improvement. So we can negotiate, and the insurance company knows the full effect of their past medical treatment as well as what to expect in the future. That is most of the cases we get. Sometimes we get a case where another lawyer had the claim and the client is, done with their medical treatment, they've had surgery. And at that point in time, we usually get everything within 1 to 2 months, because stuff is always missing from somebody else's file. And then we can negotiate the claim rather quickly. If we file a lawsuit, I would say it's 12 to 18 months to get a trial date after a lawsuit is filed. So it really just depends. Some of my clients' cases, there is a noticeable injury and not that much insurance. Those cases resolve quickly. Sometimes there's a lot of insurance, but my clients have a very bad injury, and the insurance company thinks it's worth $100,000 when we are angling for $400,000. Those cases sometimes require
Right.
a lawsuit.
Right.
So it really depends on the injury, the insurance limits, the medical treatment, and things like that. So every single case is different, and my clients know to expect. Keep me up to date with your medical treatment, and then once you're done with that, that's when we'll negotiate the claim. But there are a few exceptions, and I go into those. If one of my clients falls into those exceptions, we talk about that when we meet.
Right, right. Yeah, it really can depend on a multitude of factors, like you said, damages, the amount of insurance coverage. Liability is a big issue, especially now with the law changing. You know, recently there was the tort reform bill that was passed back in March. The law on liability has really changed a lot to where people can no longer seek recourse for an injury if they had some responsibility for the incident itself. You know, it used to
And
be
not some. It's not pure
right.
Alabama law.
It used to be, it used to be in Florida that you could be any percent at fault, and whatever percent you were not at fault, you could collect for. So if a jury came in and said, all right, trip and fall accident, premise liability cases seem to be the ones that are most common in something like this.
And yeah, I'll just pause you. So premises liability is where you're injured on someone else's property because of a hazardous condition.
Right. So like a slip and fall, a trip and fall. You know, there's always that old defense, well, you should have been watching where you're going. Right, the open and obvious defense. That is going to be raised in every single
case.
Slip and fall, trip and fall case. You should have been watching where you were going, because that's got a very common sense ring to it, and I certainly understand that. However, there are duties that are imposed upon premises owners, business owners, to make sure that their premises are safe and free from any hazards that could cause an injury, like a spilt substance on a floor in a grocery store. So, you know, a lot of times juries end up having to weigh the evidence, and they may say, well, you know what? I think the plaintiff is 60% at fault for slipping on this because they should have been watching where they're going. But, you know, at the same time, the grocery store, they really should have kept the produce area a lot cleaner. And, you know, had they done that, this wouldn't have happened. So we're going to split it up 60-40. Well, under the old law, the plaintiff could recover 40%.
Yeah.
Under the new law,
well, if you are more than 50% at fault under the current tort reform, which according to our legislators claims that insurance premiums are going to go down, and I don't know if you've looked at your insurance bill. Mine has not went down. It has done the exact opposite, but they passed tort reform to lower insurance premiums, and I have not seen any savings whatsoever. So I'm not really sure the purpose of that besides, you know, affecting injured people and limiting what they can recover.
Right, right.
But another way you say slip and fall and trip and falls, that's where juries cut the baby in half a lot of the time, where they say 50% of fault for having the tripping hazard, 50% of fault for you not watching where you're going. But it also affects motorcyclists if you're not wearing a helmet, which is not required by the law. If you're not wearing proper gear. Seat belts, I don't really side with my clients if they're not wearing a seat belt. I'm a big seat belt advocate. But seat belts certainly, but it really affects motorcyclists big time if they are not wearing proper gear, as the insurance company says, even though there's no law requiring them to wear a helmet, to wear leather or anything. But if you've ever seen someone in a motorcycle accident or been involved in one, they can get significantly injured, not even from the impact. It's from them hitting the road, their head hitting the road, them getting cut up.
It's a secondary impact oftentimes.
They can be very, very bad. But in those situations, now the insurance company argues, hey, I think you're maybe 50% at fault for not wearing proper gear, or 51% at fault, and you might get nothing.
Right.
Even if somebody cuts in front of you or hits you or runs a stop sign and hits you, they can still blame you, and that's one of the things we're facing with the new laws in Florida.
Right. It's just another risk factor that we talked about earlier. We're going to go ahead and take our first break of the night. Again, we're answering your calls live on insurance claims, so stick around and we'll be here. Thanks. Welcome back. Thanks for sticking with us. This is Law Call, where we're answering your calls live on the air. If you have a question, give us a call, 850-392-1544. And while we had a break, we did actually have an email question come in. If we go ahead and put that up, this is an email from Bart. He says, what if the at-fault driver in a wreck doesn't have enough insurance to cover your damages? Can you go after their other assets, or is this the victim just out of luck? Bart, that's a great question. Actually, it's one that we encounter fairly often, because many times people will come in and they have injuries that there is either not enough coverage for, the person didn't have insurance, didn't have enough insurance. And with Florida being a state, one of the only states I think the only state in the country that does not require a driver to carry liability coverage to cover people's injuries in case they injure them. Brian, what can people do? Let's answer Bart's first question. Can you go after the person individually?
So you can 100% go after the person individually. You are not limited to their insurance coverage. However, there are limitations to that. So it costs money to go after somebody personally. So in a case where there's $10,000 in coverage and your claim is worth $100,000, an attorney, to go after the person personally technically has to go to trial, get a judgment against them, and then start the recovery efforts. And for a standard car wreck case, it might cost $20,000 to $25,000 to go get a judgment against somebody, and then you have to pay an attorney for collection efforts. Now, in some situations, are we in a position to do collections? Yes. It is very limited. We also look at positions where people do have assets. Most of the time, I would say 99% of the time, people who do not have enough insurance coverage cannot contribute. And in Florida, which I appreciate this, there's a lot of protections from creditors. So if I cause a car wreck and somebody goes against a judgment against me, they can't take my home. Right. We have homestead protection. We have wage protections if you're head of household. There's a lot of protections that prevent what creditors can take, which is good for the most part, but can limit what injured parties can do. But in the grand scheme of things, it's probably better that you can't lose your home if you cause an accident.
Now that's in Florida. Some states actually only have homestead exemption up to a certain amount of money.
And I know we deal with this. I know Tennessee and Georgia specifically, you can foreclose on somebody's property except $25,000 or something about that.
Right.
And that is a big risk for insurance companies to take when negotiating a claim. If they decide they are wrong and a case ends up going to trial, then they are potentially risking their insured's property. So no, you are not limited to the insurance. You can go after the person personally, but we normally do a background check. We can get people's financial information through asking about it or asking for it, and then doing a simple background check is normally revealing more than enough. If it's Bill Gates, we know he has money. Who cares if he has $10,000 in insurance? If he works at Zaxby's down the road, he probably doesn't have enough money to contribute beyond his insurance policy. So we're not going to pursue someone working like that.
Right, yeah. The most common, well, it's not really common because rarely does it ever happen, and I've been doing this for close to 25 years now. I think the only time I've ever been able to actually pull money out of somebody individually is when they were just woefully underinsured themselves. And this was a very highly compensated individual. It was a physician.
We had the same case.
Who makes between $500,000 and $1 million a year, driving around with a very small liability policy. And in that particular case, there's a number of mechanisms that you can take. You can, if they don't live in Florida, you can maybe foreclose on their home. You can levy their bank accounts. You can garnish their wages. Now, it still requires you getting an order of the judge to allow you to do those things. But it's a lot easier to collect against somebody who does not have insurance but is still wealthy or has a lot of tangible assets that are not protected from creditors. The other thing, the easier way to avoid a situation where you're injured by somebody that doesn't have enough insurance or doesn't have any insurance is
underinsured motorist coverage. It is what we preach almost every single week on here. It is the cheapest insurance coverage you can buy. It kicks in the event the at-fault party does not have enough insurance or does not have any bodily injury coverage. It can be stacked. It is invaluable, and I would say I honestly don't have a percentage, but I would say half my clients have it, half don't, and almost every single one that has it, unless a commercial vehicle is involved, they are happy they paid that little bit of extra premium for that additional protection for them, their family, because you never know if somebody's driving drunk through a red light and hits you and your family, and they're uninsured, of course, because they don't even have a driver's license,
right,
you are thankful in the situations where you have the underinsured motorist coverage. And again, I cannot emphasize, it is the least expensive coverage you can get.
Right. We're going to touch on uninsured motorist coverage when we come back from our final break. Stick around. Welcome back to Law Call. Again, we're talking about insurance claims. And before we took a break, we were talking about uninsured motorist coverage. And the one thing that I really wanted to point out, and we've talked about it a lot on this show, is that if you are involved in a motor vehicle wreck in the state of Florida, the chances are you are going to get hit by somebody that does not have bodily injury liability coverage, which again is the type of coverage that would protect you if you are injured by somebody else. It's their insurance that would pay you for lost wages, medical expenses, things of that nature. Florida does not require that. And so uninsured motorist is really the only way you can protect yourself in the event you're injured in a motor vehicle wreck. Of the people that do have insurance, the vast majority of them have very minimal limits of $10,000, which $10,000 is still a lot of money. But one visit to the emergency room here locally with a CT scan and an ER visit and ambulance ride, that's going to cost you more than $10,000. And so you really ought to buy the uninsured motorist, get your policies out. If you want to have somebody at our firm look at your policy, review your policy, we're absolutely happy to do that, because at the end of the day, we want to make sure that you and your family are protected. So that's all I got to say about that until next week, when I'm sure we'll talk about it again. Brian, we're coming to the end of the show. It's time for shout outs. Do you got any shout outs that you want to give up there?
Of course. For reviewing insurance, we met with David, who owns K-Halls. A shout out to him. I love their chicken salad. It's amazing. All their food's great. But we went over his insurance with him. Ben is watching. He just texted me something I can't repeat on the air. So shout out to Ben. Michael, Jimmy. I know Jimmy's watching every week. Captain Travis, G-Money, of course, Donna and Bruce, and Miss Pam. I know you're watching. I know you were going to shout out Miss Pam, but I'm leaving your parents to you this time instead of shouting them out.
Okay. Brian always shouts out to my parents. So Pam, Brian's got you this week. But hey, Miss Pam, Mom and Dad want to give you all a shout out. Nick and Lauren, Jamie and Ed are watching us. Rick at the Marlin watching us every week. We got some very nice compliments online about Brian's tie once again. I think it's something about a Roll Tide roll. We got a few pictures we want to put up real quick. If y'all could go ahead and load those up. That is our paralegal laying down on the beach, Chris Harp. Looks like it's a little cut off, but she caught a really nice tiger shark on the beach. And then all of her Alabama friends, and it looks like one gator back there is having a big old time. There's our partner Ted Howell. He went to the Mariana class of 1998 reunion this past weekend. They had homecoming. So shout out to the class of 98 of Mariana High School. Go Bulldogs. And then the last one, that's our one of our paralegals who is going to law school shortly. Raven Taylor is getting married. We had a bridal shower at the office this past weekend, and those are all the lovely ladies of Perry and Young. Want to give a shout out to all of them as well. So again, thank you all for tuning in this week. Again, if you have any other questions, feel free to give us a call, shoot us that email, and be sure to tune in to LawCall next week for another topic.
Have a good night.
Good night.